I'd like to begin by introducing the people who will be speaking to you today. We'd start out with Jim Viola, the President and CEO of HAI. We have Sarah MacLeod, who is a managing member of Obadal, Filler, MacLeod Klein, and she is also the Executive Director of the Aeronautical Repair Station Association, or ARSA. We have Jon Kettles, who is the plaintiff's aviation attorney, an aerospace engineer, and a dual-rated ATP certified flight instructor with the Kettles Law Firm. We have Mark Dombroff, who is co-chair of the aviation practice for Fox Rothschild, excuse me. We do encourage you to ask questions. Obviously, that's why you're here, for Ask an Aviation Attorney. To ask questions, there is a module in the control panel on the right side of your screen, or there should be one. Please type out your question, and we will do our best to respond to all the questions that come in. There will be a video link that will be distributed tomorrow, probably after the fact, after this video, after the webinar is complete. It does take them a little time to render the video and post it, and we will get them out as quickly as we possibly can. Now, considering we're dealing with attorneys, we do have a bit of a notice. We want to make sure you are aware. Every legal matter is different depending on the people and the jurisdiction involved. Legal advice provided in this webinar is offered as guidance only and is not meant to replace an in-depth consultation with an attorney in your state or country. Again, those jurisdictions are different, and so every state or country will have different rules, and we will not be able to get into very specific details with your questions today. So please use this as guidance. If they tell you to consult an attorney in your area, it probably makes sense to do so. Now I'd like to turn the webinar over to Jim Viola, our President and CEO of HAI.
All right, well, good afternoon, good morning to some places, and it's always great to kick these off. I think, again, today we have a good mix of attorneys. Hopefully they're meeting the members' needs, and we still, as we get into strategic planning here at HAI, we're looking forward to figure out what are the member services that we need to provide. Of course, this year we kicked off this at work webinar on Thursdays, and we tried to pick a time that was international. Picked it in the afternoon of the East Coast, so that it also is in the morning in some parts of the world and late evenings in other parts of the world. So please give us some feedback on that. Again, I'm always open to feedback at president@rotor.org for that email. And with that, let's kick it off. We'll kick it off with Sarah. Sarah and I go back to FAA days, and it's good to be on the other side of the fence working with her now on industry. So thanks, Sarah, for kicking this off.
Thanks, and if anybody can't recognize me with my new hairdo, you can see that COVID did its number on me. And I happen to really love my new hair. I don't have to worry about anything else. So they've asked me to join this seminar because my practice is almost solely in the area of aviation safety regulations. I don't do contracts, I don't do lawsuits, I do what I consider prophylactic lawyering. You can give me the next slide, please, sir. So I started my legal career in a public defender's office, and after figuring out that I couldn't be Perry Mason of the female sex because most criminals are guilty, I moved on to become the Della Street of this law firm called Obadal. At the time, the law firm had a different name. I was the main secretary. I became the boss's direct assistant. And eventually became, as you can see, a named partner on the door. I don't think I ever gave up my secretarial skills, but Obadal, Filler, MacLeod Klein, the law firm that I helped found and am continuing to be a partner in, also includes my husband. His name is Filler. He's the second name on the door. He usually handles all of the operational issues that come into the law firm, but my passion is the Aeronautical Repair Station Association. That platform is a trade association just like HAI. It's explained on the next page, and it helps do my prophylactic lawyering. I believe that when a businessman gets into court, everybody loses, because the famous expression that when the client sees red, the lawyer sees green tends to happen. We are not in a justice system, ladies and gentlemen, we're in a legal system. And my portion of it, I actually compete with ex-FAA inspectors and other individuals that are non-lawyers in the area of aviation safety regulations. The next two gentlemen, starting with Jon, are actual lawyers. They end up in court. They help you when the brown stuff really hits the fan and you're really having a bad day. Oftentimes I collaborate with lawyers like Jon and Mark because they aren't experts necessarily in the technical arenas that we have to deal with in the Aeronautical Repair Station Association and with my other members. So without further ado, that's what I do. And Jon, you're up.
Thank you, Sarah. Let's see if we have the controls here. And Dan, I think you probably still have control.
It looks like you have it, Jon. You should be able to maybe use the arrow keys on your, there we go. Looks like you got it.
Okay.
There is a bit of a lag, sorry.
Perfect. As the slide says, I represent people who have been injured in aircraft accidents or who have lost family members in aircraft accidents. I'm a plaintiff's attorney. I've been doing it for a little over 25 years. I grew up in an aviation family. My grandfather flew Sopwith Camels in World War I, bombers in World War II. 4 years ago, I watched my uncle get the Medal of Honor at the White House for helicopter rescue in Vietnam. My father was an Army aviation examiner and flew for PHI for 30 years. I spent 8 years flying fixed wing and helicopters for the Army, and actually my brother is also in the business, now an aircraft broker. So, and plus I grew up in Lafayette, watched my dad fly offshore. My undergrad is in aerospace engineering, dual rated ATP CF II. Like I said, used to work with the Army, and I actually worked at the Army Safety Center in the engineering division. We used to give engineering support to the accident investigators, and we also worked on product improvement programs such as the Black Hawk. When I was a kid, grade school, I watched my dad lose a lot of close friends offshore in aircraft accidents. And back then, there weren't any lawyers that had any background in it. So it sounds odd, but early on in high school, I knew what I wanted to do. So that's what I'm doing now is I represent people who've seen the bad side of aviation. I've handled just about every type of aircraft accident you can imagine: military, fixed wing, airline, commercial, EMS, the whole gambit. One thing that people probably don't know is if you're ever in a bad situation where you need someone like me, like a lot of people that do what I do, I work on a contingent system, meaning that I only get paid if the people I represent receive compensation. So what's nice is I have the luxury of representing the people I like in the cases I believe in. And one thing that keeps me perfectly aligned with my people is if they don't get paid, I don't get paid. So that's probably something that people don't realize about that. I used to write a column in the Rotor magazine. Some of you may have seen it. Just real briefly, and then, I speak in the news, answer general questions. Just real briefly, on the front end, people ask me, what do you do if something happens? And if you're working for an operator, you probably have instructions about what you can and can't say, what you have to say. And one takeaway is you don't have to answer questions if something happens. You may have to produce documents, but you don't have to answer questions. One thing I wanted to share is what a lot of people don't realize is just something that I get questions on all the time is the NTSB investigation process. And to put it in context, I like this cartoon because I think it sums it up. If you start out with an accident, okay, we have a chicken in a chicken coop. We have the NTSB on scene, okay? Very quickly, the NTSB has some foxes: the manufacturer's fox, the operator, and the maintainer. And that is the group of people that are advising the NTSB probably what happened, because the NTSB is well-meaning, but they don't have the scope of experience that those three organizations normally have. And as you can imagine, this is what the foxes usually tell the NTSB. Sure looks like the chicken's fault to us. And so that's a snapshot cartoon to get across, I think, what goes on in NTSB process. Hopefully this will prompt some questions, discussions, but that's a short version of what the area I deal with. If we go back to the front end, this is what I tell people. They should ask themselves if they don't want to need me or they don't want to meet me on the other side of a table. What would a very cautious, confident, and prudent person do? If you follow that question, you'll never see me on the other side of the table. And if you're riding with people that follow that question, you'll never need me. And there's my contact information afterwards if you have more questions. And next up is Mark Dombroff, and he handles the defense side. And Mark can kind of give you a short overview of what he does for people.
Thanks very much, John, and thank you, Sarah. And most importantly, thank you to HAI and Jim and Dan for putting this program together. I think it's a relatively unique program. I'm Mark Dombroff. I co-chair the aviation industry practice at Fox Rothschild. I hesitate to say this, but I have been in the practice of aviation law for close to twice the amount of time John gave you, and I would remind you and say 25 years, but I don't want to do that. We have 27 offices throughout the United States. We have an international practice because aviation is international in scope. And we focus on all aspects of the law that any entity within the aviation industry might require. Next slide, please, Dan. My background is I actually started out of law school as an FAA attorney at headquarters. After a relatively short time, about a year and a half, I moved over to the Department of Justice Civil Division, where I spent about 15 years, and I was the director of, as I describe it, all things aviation for the Department of Justice. And our largest client was the FAA. We represented the NTSB, all the military services, the weather service, any government aviation activity. And after leaving the Department of Justice, I went into private practice and have been representing all aspects of the aviation industry since leaving the department. And that includes airmen, airlines, operators, FBOs, MROs, manufacturers, airports. Since drones, UAS, or aircraft, we have a very significant drone practice. We've had and continue to have a significant practice within the rotor wing area, whether it's the engine manufacturers, the airframe manufacturers. We have about 25 lawyers that deal in this area, whether it's NTSB and whether FAA or whatever. Next slide, please, Dan. We deal with all of the alphabet agencies, the FAA, the Department of Transportation, Department of Homeland Security, TSA, Department of State, NTSB. If it touches aviation or touches the aviation industry, our lawyers deal with it. We, for example, the immediate past general counsel of the NTSB is one of our lawyers. The most senior, recently retired regulatory lawyer from the chief counsel's office is one of our lawyers. We've got a lot of connections, including my own, that run back into the government. We do regulatory work with all these agencies, enforcement work on behalf of the industry. One area that we engage in heavily, because sort of along the lines that John described, as I tell every client, a prospective client, is the worst time to meet us is after the accident or the incident occurred. So we do a lot of emergency preparation with our clients, a lot of emergency response. If you go to our website and or our blog, you'll see that information shortly. And go to the aviation tab. We have under the resources section an almost 400-page emergency response manual that you can download. And we have those relationships before the event ever occurs, so that you don't have to build confidence and familiarity with us once the event has occurred. We deal with liability-related issues, insurance issues. We've tried among our group, probably over the course of our careers, hundreds of cases in federal and state court arising out of aviation matters, labor and employment matters involving the aviation industry, because as we point out, the aviation industry is so regulated that those regulations touch virtually every aspect of a company doing business within the industry. And whether it's labor and employment, commercial, corporate, transactional, buying, selling, leasing airplane. We've done everything from 747s to Beech Barons. We deal with hazmat. We have a case right now involving hazmat allegations, both litigation-wise as well as enforcement and regulatory-wise. Drug and alcohol programs and the outcome of those programs when audits are done. The Safety Act. I don't know how many of you are familiar with the Safety Act, but it's a piece of legislation that postdates 9/11, and it provides immunity to companies so long as they comply with certain requirements. And the aviation industry, because it is so regulated, is in an excellent position to get this Safety Act protection, which we help companies get. And then finally, the unmanned aircraft system area, drones. We have a very large drone practice because, after all, as I think all of you know, drones are airplanes and airplanes are regulated by the FAA. So we, for example, assisted and represent Flight Forward, which is UPS's drone operation. Dan, slide please. I think all this information will be available to you after, as Dan said, so you don't really have to copy it down. But our blog is sort of a cutting edge blog. We try to comment on developments in the aviation industry. This upcoming February, and knock on wood, it'll still be in person. We have our 15th annual Aviation Symposium. Information's available on our blog regarding the symposium, February 2nd through 4th here in Virginia. Our aviation directory describes the full scope of the legal specialties that we bring to the aviation industry. And we have an app you can download from your app store that gives you access to all of our resources and information about our immediate past symposium, our 14th annual symposium this past February. I think we were probably one of the last, if not the last, large aviation gathering. We had about 500 people before the lockdown. And if we go forward, as I'm optimistic we will, on February 2nd of 2021, I just noted that says 2020, it should be 2021. We will be one of the first, if not the first, aviation industry event to take place live and in person following the lockdown. Final slide, please, Dan. And there's my contact information, and that'll certainly be available to you. And again, the worst time to meet people like, as Jon said, people like me or people like Sarah are after the problem presents itself, when you really are in a position of needing people you can trust and rely on. With that having been said, thank you, Dan. I'll turn it back to you.
Okay, I appreciate that, Mark. I appreciate that, everybody. Let's go ahead and have everybody bring your cameras back up, please. Jon, thank you. Sarah, thank you. And Mark, we need to have you come back up. So strangely enough, we are getting questions from the audience. So, hey, we'll get started off with one from Rebecca Torres. She says that she's in a legal battle to get money back from a helicopter flight school. I already have an attorney, but any thoughts or advice that these aviation attorneys could provide regarding flight schools keeping money from students? She says it was hard for me to find an attorney that could assist her on the matter, and I understand she's in Georgia.
Okay, so
John, you're the plaintiff's lawyer.
yeah, well, that's true. I was just going to say that the FAA isn't involved in that necessarily at all. So my expertise is, I'd say go find yourself a good contract lawyer. And if the person doesn't understand that it's a contract, then they need to talk to somebody like Jon.
And Dan, I agree with Sarah. It sounds like a simple contract issue. Just coincidentally, it involves aviation, but it sounds like it'd be more of an education contract issue, not an aviation issue.
That does help, I'm certain. It's one of those things where there probably is more information than what is provided in the question, and it's something that the consultation would reveal, obviously.
Sure.
We have our next question.
You say aviation and they go, oh, I don't know anything about aviation. And as both Mark and Jon point out, all of the business associated with aviation is business. And all of the protections that you need and good bookkeeping and good accounting and good quality system, that shouldn't change for any maintenance organization or person performing maintenance. So it is important to understand the difference between when the regulations affect something and when it's pure business. It's only Jon that'll screw us up in the end. I'm just kidding, but you really have to have a really good basis for your business in aviation or any other industry, especially one that's heavily regulated like ours is.
Our next question is from Eric Fraser, who has been with us before. We welcome him back. How effective are release of liability forms with respect to passengers being informed and understanding the risks of flight and requiring acknowledgement and signing such forms before embarking on a flight?
Let me take a crack at this. I think that's really a good question. And when we talk about release of liability forms, oftentimes, at least what jumps to my mind is you walk out to the ramp just before you board the airplane, or as you're writing your check within the office, they ask you to sign a release of liability. And it's not unlike the releases of liability that you are asked to sign in other places. The starting point for whether or not a release of liability is enforceable is state law, the state in which the activity is taking place. As a general matter, it's been my experience that releases of liability, hold harmless provisions, the person walks out to the airplane, is asked to sign it, and they sign it recognizing that if they don't sign it, they're not going to get on the airplane. They sign it, sometimes without reading it, are generally disfavored by many courts. I think if you are if you're an operator, a tour operator, you're going to fly a photographer around and you want to have a release of liability, one of the things you're going to have to look at or have a lawyer look at is what's the state law where you are doing business that addresses the enforceability of hold harmless waivers of liability, because you want to make sure that the language in there and when you provide it to them time-wise prior to the flight is compliant with whatever the courts or the legislature has said. The problem if you don't do it, if you don't have the right language or you don't provide it to them in advance, if that's what the law requires in that state, it won't be enforced. And I think you've got to really look at those, because if they're enforced, you're off the hook if something happens. The other issue is the scope of the release. You may not be able to get a waiver or a hold harmless for gross conduct, reckless conduct, intentional conduct. So once again, you've got to understand when you're putting this document in front of an individual, what the limitations are and the requirements are under state law. And I think, you know, I won't say any lawyer, but a lawyer who understands this issue of liability, and it could be a plaintiff's lawyer, it could be a defense lawyer, but somebody who understands the scope of the law, or at least knows how to look it up in that particular jurisdiction, should be talked to.
And Dan, from the plaintiff's perspective, I agree with Mark that it's dependent on which state law would apply. From the plaintiff's perspective, they're usually just an annoyance or cause problems. Some of the key requirements are a person being fully informed. So that's a big gray area. And then, like Mark said, the scope. You can't waive gross negligence. And so both you look at how well the person is informed and what's the scope of what they're trying to give up. I hate those with a passion because, frankly, it's irresponsible. From an operator standpoint, you're asking people to give you a license to be irresponsible. So from both a philosophical perspective, I disagree with the basic concept. So if you're an operator, you need to question who's asking you to get that signed. Are you going to get a reduction in your insurance premiums because you have your passengers sign a waiver? I doubt it. So get back to why you're being asked to have your passengers sign it. Because when you look at it, you're asking a passenger to give you a right to screw up and not be held accountable. That's why I disagree with them. But back to Mark's general comments, I agree that it depends on what jurisdiction you're in, but most often they just complicate the fight, but rarely resolve anything.
Well, gentlemen, wouldn't the first question be what type of operation we're talking about? If it's a 119, then John's closer to, you know, it's barely worth the paper it's written on. But if I'm sharing a flight or I'm just a 91 operator, wouldn't it make a difference? Again, it depends on the state law, but John, I can never, hold on just a second, Mark. I can never waive my careless and reckless. I mean, the agency is going to get me and everybody else is. But again, if I'm just a private pilot and I just want to make sure the person understands that I'm not a professional and I'm not, et cetera, et cetera. So, all right, it depends.
Yeah, I know. I think that your last two words in many respects sort of sums it up from a legal perspective, no matter what side of the table you're sitting on. It depends. And the one thing that I think is a positive as it relates to waivers of liability, hold harmless agreements, in whatever context they're used, is that I think I have to believe, and I've certainly, the one that jumps to mind as I remember, I argued one actually in front of the Alaska Supreme Court involving a hold harmless waiver liability in an accident, is that the law in virtually every state of the 50 states is well developed as to how they view hold harmless agreements, what the requirements are, and so forth and so on. And I think, you know, I understand exactly what John said about philosophically not agreeing with them, but, you know, just from the legal perspective, philosophically, those are arguments that one can make. But the law is pretty developed as to whether they're enforceable, and if they are going to be enforceable, what elements are required to make them enforceable.
Okay, I'm going to jump in before we go too much further on the same question. I understand we could get a long discussion on each one of these. We welcome back a question from Jim Hausch, who's been a previous webinar participant. I understand reversion clauses in hangar leases are legal and enforceable, but are not required by grant assurances. What do you think about getting some guardrails around the process of property reversion at airports that accept FAA grants or funds?
So let me jump in. And the reason I want to jump in is that I literally, just behind me on my table is an airport lease that an FBO client sent to me that involves another potential FBO and airport assurances and FAA money, and what the processes are with respect to that whole area. And I guess I've gotten, because we're actually involved in an issue in which one of our clients has filed a complaint with the FAA regarding the airport at which they're located, and their lease to somebody else involving certain property at the airport. I'm not sure I can answer the question directly, but I can tell you that I'm not at all confident that airports, generally airports in this country, particularly when you're talking about smaller airports as opposed to the large airport community, understand all the strings that come with accepting funds from the FAA under the airports program. They don't really understand the reach that their obligations stretch. And so I certainly think, as I said to the client today, it's amazing that this question got asked, because I was on the phone with the general counsel of the client today. I think that airports do things in their leases that offend people who are already tenants on the airport, and the airport doesn't fully understand, the airport commission, the airport manager, the city council doesn't fully understand the reach of the FAA once you've accepted funds. So I think it's definitely an area worth looking at, but I think a lawyer would have to look at the lease, the documents and issue and so forth and so on. But I think it's an area of some interest, and it's sort of coincidental that it's something that's literally open on my desk.
I support that, Mark. Marshall used to do that. My husband that's in part-retirement used to do that, and he found that a lot of airports are not knowledgeable of the strings attached. And it's well worth getting your leases reviewed by an experienced aviation lawyer that understands that.
My observation to your comment, Sarah, is how can it possibly be that Marshall and I practice law at the FAA together, and he's in retirement and I'm in the office? No answer called for.
Hey, he doesn't have walnut walls. That's all I'm going to tell you.
Okay, we actually have questions related to the COVID pandemic. We'll start with one from Jason. We have a mayor who imposes specific restrictions on only helicopter tours in the respect to COVID. I feel that the mayor specifically singled out helicopter tours and said we were now not allowed to operate. What is the jurisdiction of a city in regards to our business? And this is not a violation of grant assurance, or this is not a violation of grant assurances.
So that's the famous "it depends" answer for sure. A lot more would have to be known.
Here's, I'll just, I think Sarah's absolutely right. You need to know exactly what the restrictions are that the mayor has imposed. You also have to look at the licenses. And I'm not talking about FAA certificates. I'm talking about the city, county, state licenses that the tour operator may hold, because the city can't do anything or say anything that restricts the operation of any aviation industry certificate holder, FAA certificate holder, because the FAA has preempted that area. But it's not unlike the bar that holds the liquor license, and the city restricts the number of people in the bar due to COVID-19. You can violate it, but then your license, your city issued license, may come in, into risk. But this is an area which I think, as Sarah says, requires a lot more information. I think the phrase arbitrary and capricious comes to mind. If they're restricting just helicopter operators and not or tour operators, and not restricting some other kinds of operations that are equivalent by way of social distancing or whatever the reason is for the restrictions, you could probably make some arbitrary and capricious arguments that the helicopter operator is being singled out arbitrarily and capriciously. But again, this is one where more information is needed from that perspective, I would think.
Okay, we have one from Dorothy. Can the panel comment on the liability of carriers for COVID-19 exposure?
John, you're the. I certainly have something to say about it, but go ahead, John.
Sure. One is it's beyond. It's not an aviation specific question. You're going to see a rash of probably lawsuits, but you're also going to see a rash of liability protections. And I believe the way the law is going to probably come down on that is reasonableness. And that's the standard whenever you have an accident, a crash, okay? Say Part 91 operation. A person or operator is held to a reasonableness standard. What would a reasonably prudent person do in the same or similar circumstance? If you're a, say, 135 or commercial carrier, it's a higher standard. What would a very careful, cautious, and prudent person do? So those are the two standards. 91 common carrier, 91 common reasonableness. Whereas if you're getting paid for it, you're held to a higher standard. For example, when you get on an airliner, you get off the jetway, step on the airplane, you hang a right and go find your seat. You just put your life in the hands of the people driving that iron or aluminum tube, and you put your hands in the life of every person that touched that airplane. Same thing with a helicopter. Imagine 50 people with their paws all over a helicopter. Every one of those people can have an effect on whether you land safely. Okay, so getting back to your question on COVID, I think the way it's going to play out, I believe it should play out, is did the operators, the airline, the 135, or whatever it is, did they act reasonably protecting you from COVID? I think that's the standard that should apply, and hopefully the legislature won't give a bunch of people immunity. But I think that's probably the answer, is if companies act reasonably, then they won't be responsible. However, if they don't, they'll be held liable.
You know, let me, if I can, let me follow up John's comments. I actually had a discussion with a couple of our airline clients, both 135 operators as well as Part 121 operators, as well as cargo operators, I guess. And the real problem is, one, just as an observation, the FAA has not given any guidance or direction to the airlines. They've deferred to the CDC. And I don't know how many of the attendees out there have actually flown commercially since this whole thing started. I have, and I got to tell you that I was much more comfortable in the airport experience and on the airplane than I was when 4 days after I got back to Washington, and I went just as a precaution to get a COVID test, and they shoved the swab up my nose. The airlines have individually and collectively done a really, really good job. Now, the public's going to take a while coming back to fly, obviously, and certainly the business public, the business traveling public. But I'll tell you the big problem with liability for anybody with respect to COVID, and that's proving causation. That's going to be the real problem. Under the law, in order to demonstrate that there's liability, you've got to demonstrate that something the carrier did caused the injury. Now, if the airplane crashes, it's, as John says, it's the highest degree of care. You have a contract, it's your ticket or your charter agreement or whatever. You have a contract that says they'll get you from point A to point B safely. And if they have an unscheduled stop in the middle and it's a smoking hole in the ground, they've breached their contract. The COVID issue is a whole different issue. You travel to Los Angeles the way I did, and then 6 days after you get back or 2 weeks after you get back, you're tested positive for COVID. Well, wait a second. What did you do in those 2 weeks? Who'd you talk to? You stayed in the house the whole time? You didn't see anybody? You didn't talk to anybody? You didn't touch anything? Proving causation is going to be a very, very steep hill. Right now, I know this because I've had the discussions with the insurers and the brokers about it, because the airlines have had claims presented to them of COVID. They've paid none of them, and the insurers don't even believe that it's covered under the insurance policies that they issued the airlines. So it's an unsettled area. And in my cynical way as a defense lawyer representing the industry, when you have unsettled areas, plaintiffs' lawyers will always jump in to try to get it settled. So I think there ultimately will be lawsuits, but it's going to be a really tough road to hoe. And that's one area where no airline has asked anybody to sign a waiver of liability regarding COVID. So, you know, the reality is, just based upon my observation, and I'm a really critical observer when it comes to safety issues on the carriers that I fly, the industry is really good. The events we hear about are the anomalies, the fights on the airplanes, the people being removed. Those are truly the anomalous situations.
Okay, I think this one was from Michael Tarling. It was identified for Mark, but I think it's actually for Jon. Please explain why the manufacturer is essential to an accident investigation and not necessarily the predator fox.
I can start off. Well, I think they are the fox. But as far as to answer your question, why they're essential, I don't believe they are. But I think what the NTSB does is they bring them in as a technical expert. Under the federal regulations that govern their conduct, it's fairly tight. They are invited to participate, and their purpose is to provide technical expertise. And they're not allowed to hold anything back from the NTSB. Now, regulation and actual practical application, there's usually a difference, but they're not allowed to hold anything back if they're participating. And then after, when the NTSB investigation is completed, they're not allowed to keep secret anything they learned as a party participant. So they're brought in for their expertise, but the problem is with the system is they have an incredible amount of influence on the NTSB investigation. They are allowed to sometimes write the reports, they edit the reports, and so they are right in the middle of producing the NTSB end product. And so that's why I believe that they have undue influence in the process.
They also have the most vested interest in the process, because if they truly are safety conscious, and I'm sorry, I don't believe that the major manufacturers are not safety conscious, they have the most vested interest. You don't go after the FAA for that accident, Jon. You go after the manufacturer. And no matter whether the FAA approved it or not, the manufacturer is still responsible. It should have the best expertise. The NTSB's analysis, I agree with you, hasn't always been correct. I'm on the MRO side, and we're thrown under the bus all of the time because we're not a required party to the investigation. The only required party, my understanding, is the FAA itself. The rest come in by the investigator in charge process, and he can limit or not the involvement. And as you said, the signature you have to put on the piece of paper when you become a party is that you are for safety. Of course, no law will get us the morals and all of the obligations we have to have. And I agree, but I think this process is pretty good. And we certainly have had the ability to input information, even not being a party, if it is technical in nature.
In one thing I want to basically echo from what Sarah mentioned is the regulations allow the NTSB to invite the manufacturers to be what I call inside the circus tent. the same regulations prohibit people like me or the people who have been injured, family members. They prohibit those people, the people that have the real personal vested interest in what happened and why. Those people are prohibited by federal law from participating. So not only do they not invite them, they exclude them from the process. And so that's why I think the manufacturers have undue influence, because rules keep people from, like me, from being able to even, we can't even observe. And the best we can do is we have to play catch up after the fact. And that's why we always do, from the plaintiff's perspective, we have to do a parallel investigation. And quite often, I'll send information to the NTSB investigator early on, so that they get the information that I think the manufacturer should be giving them, and maybe they don't. Sometimes they complain, but it usually gets their attention when I send them things.
Let me, Dan, let me jump in here. Look, I've lived with this issue my whole professional career. The NTSB has what's called a party system, and they invite as parties those entities which are in a position to make a technical contribution to the investigation. That involves manufacturers, airlines. It may involve MROs, repair stations. If it's a foreign aircraft, they'd invite Airbus. They would invite the AAIB, the Accident Investigation Authorities in England, to be observers and so forth. The reality is that the NTSB process is not a litigative investigative process. And as John points out, over the years, the NTSB has been attacked and actually sued by plaintiffs' lawyers because they want the families, the victims, to be parties to the investigation. And the simple fact is they have no technical contribution to make to the investigation. If my family member is killed, in order to make a technical contribution, I would have to hire an expert to have the technical background. And the fact is, the NTSB doesn't even allow the manufacturer of the airline to hire somebody to be their party representative. They've got to be employees of the company. You can't hire consultants. It is quite literally the gold standard in terms of accident investigation authorities and processes in the world. And I've dealt with them throughout the world and deal with them now throughout the world. And, you know, there's always going to be constituencies that attack the system. And it's accurate. Companies that manufacture aircraft or components or engines or airlines are far more knowledgeable regarding their operation and their product than the NTSB could ever be. And so it really becomes an issue of the NTSB evaluating and filtering the information. And it's never going to be perfect, but I'll tell you something, it's pretty damn good. And I would be firmly, unalterably opposed to letting family members and victims be party to investigations. Then it turns into a circus whose sole purpose is litigation. And I think that the whole process essentially gets corrupted. Is that plain enough? I guess it really, that's pretty blunt.
Well, I would come down in the middle of the two of you, but Dan, you better get to the next question, because this is.
Yeah, I'm looking at the clock right now. Would you guys be okay if we run through?
Anything is technical, it should be able to be presented to the NTSB. Whether you're a party or not is a different issue. Thank you.
And Dan, one more comment I can't resist. The
Yes.
NTSB changed the rules about 5 years ago. And up until that point, anyone could submit information to the NTSB. They made it even further restrictive. Now, the NTSB only allows information from party participants, such as the manufacturers. Now, I still send them information, even though the federal regulations prohibit it, and they can't ignore it. But I think about 5 years ago, the NTSB shoved their head farther into the sand when they said, nope, only the party participants can give us information. Fortunately, on an individual level, when I send them information, they usually take it and use it. And so, you know, I'm at a point where I've got to rely on the individual responsibility of the people at the investigator level. And those people, I think, have the right interests, at the top of the priorities. But I disagree with Mark. I mean, he represents manufacturers. I represent the people who are injured. So we have, two different views of the process.
Yeah, I do need to jump in. I think we do need to advance. I think this might actually become a topic for a future webinar is the investigative process. Stacy Dorn at Paradise Helicopters. What are the regulations on adding a UAS operation to an existing certificate? Would the FAA allow the term commercial services to promote our utility flights?
I'll jump in. The answer is generally yes. If you've got a 135 certificate and you want to operate UAS for hire, for compensation or hire, you can actually add that operation to your certificate. Now, I'll tell you, and this is a matter of public record, so I don't think I know I'm not disclosing any client confidences. UPS Co., which is the airline, they obviously have a 121 certificate operating, 300 plus airplanes worldwide. But Flight Forward, which is the UPS drone operation, has a separate 135 certificate. They chose to operate under a separate certificate. So, and one of the things that was considered at the time that we were talking with them about it is should they simply add that to their 121 certificate? And the decision was made not to mix the operations and somehow have overlaps and create issues for the 121 certificate during the formative growth of the 135 operation. But the answer is yes. The biggest issue that you will encounter right now is getting the FAA, whether it's the local FSDO or it's the UAS folks at Washington headquarters, to focus on giving you a certificate or expanding your current certificate operations, only because of the workloads and the demands on them and the various pilot programs they have going and so forth.
So they wouldn't be open to just adding that as an aircraft type?
I think our experience, it's a good question. Our experience is that the FSDO, and I'm thinking of one FSDO in particular that just told a client, you really have to go to Washington. Here's the person to talk to. And the response they got from Washington, and the whole thing is right now in a state of flux, was we can't deal with that right now. But the answer is you should be able to add another aircraft type to your Part 135, but you still have to make sure that the organizational structure of your existing 135 is focused on UAS as well. And there are, as we all know, differences.
If it's 10 or under, Mark, I mean, the maintenance information would be the same, the inspection requirements. I mean, that system is in place. So, okay, so my experience is ask not what the government will do for you, ask what you need to do to get the government to move. So the first thing is look at the present regulations, understand UAS is an aircraft, and if it fits in that operation, go to somebody like Mark or, well, can't go to Jon, and get the showing completely in line with the regulations, and just don't take no for an answer.
Okay, I'm going to jump in and move on with another question. This one I'm going to have to explain a little bit. Do you have any insider example cases in which organizational PAVE, which is pilot, aircraft, environmental, or external pressures on a flight crew have led to organizational liability? And I can read back through that again.
Culture of the corporate culture of the air carrier or what have you led to the accident? I mean, NTSB found that in the Continental Express accident.
Sure, I agree with Sarah. I mean, that's an issue all of the time as far as corporate pressure, especially EMS flights, go, no-go decisions. I mean, if you're talking about general corporate pressure, that's a huge issue.
Yeah, I think the concept of get there-itis or get home-itis, because the pilots are carrying the chairman of the board or the president or some senior management in the back and they want to get home, is always an issue that's looked at. I think that I can think of a corporate accident in which, in fact, I can think of a couple of them where that was thrown out there. You know, one could say these were clearly pilot error accidents, but the assertions were that the pilot error was driven by corporate pressures associated with the operation. I think the NTSB has certainly discussed it in a number of accidents. And when Sarah mentions Continental Express, they're talking about, I think you're talking about Continental 3407, which was the accident up in Buffalo, New York. And there you had a co-pilot who deadheaded from Seattle to her base, got virtually no rest, even though she had sufficient time off and compliant with the regulations in the airline's program. She deadheaded on another airplane, and it was clear that she did not take advantage of the rest periods and got on the airplane. And if you're not familiar with 3407, it's sort of a classic case of pilot co-pilot error, not paying any attention to the airplane and what it was trying to tell them. So yes, it's a very, I'll call it live issue in the liability area. Most corporations that we represent, they've got very, very stringent rules, and it's pretty clear that it's made clear, not to the pilot, not to the corporate pilot, whether employee or contract, but made clear to the chairman of the board and the president and anybody that uses the airplanes that the pilot decides whether that airplane goes, not you. You have no say in it. And it's really driving home to the corporate side of the operation and not the aviation side of the operation.
Well, I'm just going to tell every pilot out there that they have a hell of a lot more power than the chairman of the board.
That's right.
And if it is your job or the safety of the flight, you don't have a choice when you have a certificate.
Right, but the reality is they have employment concerns, their own employment concerns. I mean, it's an issue in the Kobe Bryant crash, and I would say it's probably an issue in probably 75–80% of the accidents. There's the regulations versus the reality. And it's, I mean, it's a tough call for a pilot working pilot wages to tell his or her boss that they can't go. It's a reality that has to be dealt with, but you see it quite often.
I'm going to interrupt again real quick if I can. We're right up against actually where we're normally supposed to stop. We do have a handful of questions left we'd like to try and get to. Are you able to go for another 15 minutes or so today?
Sure.
Okay, I appreciate that. I am going to jump in with the next question. With the FAA's significant use of advisory circulars over regulations, from a legal standpoint, how enforceable is the adherence to an advisory circular?
Courts have addressed the issue. Courts have addressed the issue. The courts have said they have no regulatory effect. They have no legal effect. That doesn't mean that they won't be introduced into evidence, and it doesn't mean a jury won't consider them, and it won't mean that John won't argue it. But the courts that have addressed this issue, and lots of courts have addressed it, have made it clear that advisory circulars are nothing more than advisory. Think of it like a speed limit that says recommended speed is 45 miles an hour on this stretch of the road. And if you do 60 miles an hour and the cop pulls you over, they can't cite you for speeding. It's not a speed limit, it's a recommendation. The same thing is true under the law with advisory circulars. Now, you put it in the context of litigation in the courtroom, you know, it may take a different color, and a judge may instruct a jury that the advisory circular that was introduced into evidence is not mandatory, but you may consider it, so forth and so on.
So the FAA has issued a legal opinion that one of its advisory circulars was incorrect, and the FAA legal opinion said that, gee, that's too bad. You're responsible for compliance with the regulation. So they don't even stand behind Thanks. Now, of course, this Department of Transportation is requiring all advisory circulars to go through the lawyers because the Department of Transportation passed regulation that makes guidance material basically regulation. So they do have to ask for public input, et cetera, et cetera. That does not stop the local inspector from using advisory circulars, its orders, which have absolutely no effect on the certificate holder. The only thing that the certificate holder must be able to show is compliance with the regulation. Now, a lot of the regulations are performance-based. So the proof of the pudding is in the eating. You have to fly an airworthy aircraft. Does that mean you have to fix every cup holder that's broken? Probably not. But you have to be ready to understand what your obligation is to show compliance. And if you do have a question, I mean, you know, that's what HAI, go get opinions from your other operators, start listening to what other operators are quote unquote getting away with, and compare it to the rule, not to what you're doing. What does the rule say? Does a rule allow it? What's not prohibited is allowed. I just had a FAA inspector kick back a repair station quality manual because we had no support for putting a particular process in the manual. And so I wrote back and said, tell me the rule you're going to enforce. If it's not prohibited, I can put this in my manual. So again, you have to understand the job of the government is to find compliance. Your job is to show compliance. If an advisory circular helps that effort, great, but follow the rule.
And Dan, on the front end, since the question is being asked now and not after the fact, I think the important thing for people that are trying to decide whether they're going to follow the guidance in an advisory circular is back to that core question. What would a very careful, cautious, and prudent person do? Would a very careful, cautious, and prudent person ignore the guidance in the advisory circular? If you can say yes, then ignore it. But I doubt you can say yes. So you should roll that in. And I agree with Mark that it may not have regulatory effect, but it certainly is going to be rolled into what you should have done.
Okay, I'm going to jump on to the next question real quick. I think I'm going to interpret this correctly from David Betancourt. Does enforcement counsel in CP cases, and I think CP would be consumer protection cases, is that a reasonable assumption?
Civil penalty
cases. Excuse me. Thank you for clarification. Does enforcement counsel in civil penalty cases comply with the new disclosure requirements for sanction penalties under the new 49 CFR 5.97?
49 is Department of Transportation.
Well, I guess I'm not clear, and if we can get clarification, when you say does enforcement counsel comply, one, I assume you're talking, the question is in the context of does FAA enforcement counsel comply, and I guess the question is comply in what respect? I think we can answer that question, or can answer that question, but I suppose I need a little more clarification.
Okay, I see David is still online, so hopefully he can put another question and we can try and get some elaboration for you. We'll go on to the next question. Kelly Parlier, what background and experience in the aviation business are aviation attorneys required to have?
None.
I see smiles all around.
I can lead off on that one. There's no requirement, and I mean that's the reason it's I do what I do because of my background, and it's an advantage for me because the vast majority of defense lawyers have no technical expertise or no technical experience. So when I'm mixing it up with an aerospace engineer, I have a better feel. I mean, I use outside experts, but I've flown helicopters, airplanes. I've flown enough to scare myself, and so that's why on a personal level I give information to the NTSB because I do a lot of my own investigation. Answer Kelly's question, that's one of the problems. There's no requirements. So
Well, okay, John.
a pilot's license and a pilot's license and a law degree do not equal an aviation lawyer. There's an experience, I think, level, like for example, Sarah and Mark, they've got the experience where they've been doing it long enough where they have the background. They've seen, they've seen it all. And so, and from my view as a plaintiff's lawyer, I've been doing it long enough where I've seen just about every way you can try to crash an aircraft. But what I think I bring to it, which is a little different than most plaintiffs lawyers, is, I've flown these things, and most of the aircraft I deal with, I've flown them or things like that.
Okay, so lawyers have professional ethics. You don't get to take on a case that you don't know your ass from your elbow about. If you do, then fire a lawyer and find a new one. So the bottom line is that we do have professional ethics. I know that reality is different, okay, because there's a lot of educated idiots out there, and the certificate doesn't mean that you can know what you're doing. Just like a mechanic certificate. You get the mechanic certificate, then you get to learn. And we do practice law for a long time. Eventually, you should be asking the right questions, getting the right expertise, understanding my area is simply the same law that every pilot and mechanic practices every day. I can translate some of the technical issues now, and I can't stand toe-to-toe with some aeronautical engineers because I'm just reading the rule and asking them to explain it to me. And if they can't explain it to me, I figure they can't explain it to a federal judge. So there's a lot of knowledge that you bring to the table that no matter how experienced I am, I'm going to suck knowledge out of you to make sure that you have a good case or that I understand what your objectives are, etc. So some of that's lawyering, John, and some of that's aviation law.
I'll add one observation. When I was at the Department of Justice and I took over aviation, the theory was that they would only hire lawyers who were pilots to be in the aviation unit of the Department of Justice. And as soon as I took over, and for as long as I ran the place, my view was entirely different. I wanted people that were the best lawyers I could find to represent the United States, and we could teach them everything they needed to know about aviation.
Okay, let's see. Let's go to a question from Dan, who's a member of our safety working group. If an aircraft is owned by the same owners and utilized by two separate companies, can an aircraft be listed on two separate FAA operating certificates?
Yeah, so that's, to me, there are no states. There are some states that certify lawyers in the aviation area, but that's not an indicator of anything, in my opinion. You got to talk to the lawyer and find out what their experience is. And if somebody says, well, I'm a pilot, to me, that means nothing. You look at John's experience, it goes well beyond being just a pilot. So you want somebody that you're comfortable with and confident in. And if some lawyer accepts the case, and unfortunately I've seen it a lot, a lawyer, I'll take a helicopter operator. You guys have corporate lawyers, they handle your leases, they may handle public aspects if you're a publicly traded company. But the simple fact of the matter is they probably don't know anything about the regulated world of aviation. And my advice typically to those companies is don't use your corporate lawyer when you get a smoking hole in the ground. You need somebody that understands the way the system works.
Unfortunately, Dan, Mark is going to have to answer the next question because I'm not very strong in the 135, 121 world.
I'm going to pass out on that, the David Betancourt question, because I think we're going to have to actually answer that one offline. We're going to go ahead and try and wrap up now. We're getting close to our time, and I've got a few things that it'll be for housekeeping. So I'm going to follow up with Ben Lewis's question. As a pilot in the industry, is it generally recommended to have a specific aviation law office in mind or on retainer, or is it best to wait until it's needed? If it's necessary, what is the best way to find the best fit for an individual?
So this is an individual, he's not working for another company, he's not.
It does not state that. It just says as a pilot in the industry. So we'll leave it at that. If he's looking for an independent attorney.
Look, prophylactic lawyering means you understand your obligations, you understand, and you're semi-paranoid, right? Just because you're paranoid doesn't mean they're not out to get you. So if you'd like to talk to a plaintiff lawyer to say, all right, when would I ever get sued? And spend an hour with him and then an hour with Mark and an hour with me, it's probably well worth the prophylactics of that. I'm not very expensive. I don't know about the other blokes, but I mean, it never hurts to find out who's going to be against you. But hire one, you know, to know them, to participate in some online seminars, to listen to them, absolutely. Go out and find out who you might want to call.
I think if you just Google aviation lawyers, you'll find an awful lot of people. You know, I know my name pops up. I'm sure John's name pops up, and so forth. I think if you're an individual pilot and you have in mind certificate actions, you know, somebody's going to go after your pilot certificate. You know, I'm sure NBAA and I know AOPA all have panels of lawyers that are part of their programs and so forth. There are lawyers who specialize solely in pilot certificate actions. Yeah, and you know, I think Sarah's advice is well taken. You know, if you want to sort of get an understanding of, you know, sort of who's out there, it doesn't hurt to call somebody, you know, whether it's John or Sarah or me or whatever, and, you know, we can sort of tell you the kind of lawyer you might need. My advice generally to companies, you know, if you're a helicopter operator, you're carrying passengers for compensation or hire, you got an insurance policy, and you don't want to meet the lawyer that's going to be representing you after the accident for the first time. And you may not like the lawyer that the insurance company is going to give you. And just because you have an insurance policy and they have the responsibility for managing the claims, it doesn't mean you have to accept that lawyer. And I make it clear to clients, and we have lots of clients that have not had an accident, and I participate in their emergency response drills and their training and briefing their management and the NTSB process and how to deal with the passenger issues and how to deal with the media and so forth. And it gives them a peace of mind and a comfort and a phone number in their wallet or on their iPhone if, God forbid, something happens. So, you know, I think you'll find people like John and Sarah and myself are very forthcoming and opening and talking with you about those things. And there's no bill for it.
Well, and also we have, you know, because we're colleagues, we, you know, can refer you to somebody that's going to be better or that you should talk to or what have you. I mean, Mark's business and my business sometimes is also working with a corporate lawyer to make sure the language is right, HR to make sure drug and alcohol testing is done properly, et cetera, et cetera. And unfortunately, the aviation business is one of the most regulated in the world, whether you're an individual or a corporation. We compete with the nuclear power industry, except we go.
That's correct.
Okay, well, I do appreciate Sarah, John, Mark. The time that you provided us today has been fantastic. The experience that I've had out of this has been amazing. I am grateful that you were willing to take some time today to share your knowledge with us. What was more fun than a room with one lawyer? A room with 3 lawyers in it today. So I certainly appreciate all the time you provided for us. I think that we will probably have to try to hold one of these webinars again in the future, because I see there were still questions that we just were not able to get to. Thank you so much. I'll go ahead and deal with our some of our last minute housekeeping details today.
Thank you, Dan.
Thanks, John. Thanks, Mark, and thanks, Sarah. Save the date. Our next 3 HAI at work webinars, October 8th, managing risk in hazardous environments. That's going to be what an average person can learn from the U.S. Coast Guard. Our panelists are all with the U.S. Coast Guard. On October 15th, we are looking at improving diversity and inclusion in our industry. That's certainly an area that we could work on. And on October 22nd, we will have representatives from the California Army National Guard who have spent the last few months fighting fires and rescuing people from those fires. All of those webinars are at 4 p.m. Eastern Time. Watch for the link in our email, in our social media, and in Rotor Daily. We do have a follow-up questionnaire coming shortly. We do ask that you take a few minutes to respond to the questionnaire. It's one of the ways that we learn what you need or what you'd like to see us present in future webinars. As also let us know how we're doing with these webinars. If you have a comment on what HAI is doing in general, we are always looking for assistance in that area as well. Let us know what we're doing right. Let us know what we're doing wrong. Let us know what we can change. Please contact the president at rotor.org with your challenges, with your questions, with your support. Jim does see every one of those emails that come in, and then he does task staff members with them when they arrive. As always, we thank you for your time. Until next week, we ask that you be safe and that you fly safe.